Hello, I'm Ken Swinton, and this talk is called Moths and Conveyancing. And no, I'm not a lepidopterist. Um, so this talk really follows on from the one I did last year on Japanese knotweed and should really be seen as a continuation of that. And it's looking particularly at uh, words such as infestation and vermin in relation to standard clauses. So hopefully it'll be of some interest. This should be around 30 minutes of CPD, and if you want a written version of this, it is available in the September 25 edition of the Scottish Law Gazette. So, as I've said, it's a companion to the Japanese knotweed talk that I did in 2024. Since I gave that talk, um, the Scottish Standard Conditions version 6 has come out, and there have been changes in relation to the clauses dealing with wet rot, dry rot, etc. So that in 2.3, there is now a carve out into Japanese knotweed in a separate subclause, and the clauses no longer include any reference to other invasive plant species. So infestation in the Scottish Standard clauses now can only cover animals and insects. So the question that I posed was, could moths be the subject of a claim under Clause 2? And it's not entirely an academic exercise because there is a fairly recent English authority, Patar Chatsishvili against Woodward Fisher, 25 England and Wales High Court, 265 Chancery. So I accept an English authority is at best persuasive, and a degree of caution must be applied when trying to apply a case in relation to peculiarities of the English system of conveyancing to Scottish conveyancing matters, which, as we know, are somewhat different. Nonetheless, it is instructive to look at that case, and there is a clear lesson, perhaps two lessons, to be learned from that case that I'll sum up with. So this case, let's call it Woodward Fisher, is easier to compare, I think, with Busby and another against Blair and another, which was the subject of my talk last year. That case is the Japanese knotweed case, which turned on a version of the Scottish Standard clauses that is at least two generations before the current version of the Scottish Standard clauses version 6. In Busby, it was held that infestation was not to be construed a justem generis to woodworm and rot, which were referred to by name in the clause, and infestation would be given a general interpretation by the court. Nor was the infestation restricted to buildings on the property, and it was noteworthy that the standard clauses were and continue to have definitions both of buildings and the property erected on those buildings. The result was in that case that an infestation of Japanese knotweed, which was held to be extensive and intense, was potentially within the scope of the then terms of the Scottish Standard clauses in relation to the word infestation. Now the question was this within the knowledge of the seller in that case? And the evidence was that they had treated the knotweed, which had died back and had appeared to have been killed, but wasn't. Whether it actually affected the valuation of the property is entirely another matter, because the ground in that case attached to the property extended to about 4 acres, and the knotweed was restricted to an area down a slope from the house close by a burn, which is where one might expect it to be situated. So in Woodward Fisher, the property in question was this somewhat unprepossessing mansion house on the fringes of Notting Hill in London. The defendant sold it to the plaintiffs for £32.5 million, which is fairly remarkable because he'd bought it about 4 or 5 years earlier for £10.4 million. The explanation for the massive uplift in price was that he had created 2 basement subfloors and had fitted the whole property out with high-end interiors, as well as an extension to the rear. Now, the key to the case was that he had difficulty in obtaining planning permission for these somewhat grandiose plans, and in order to secure permission, had upped the eco-credentials of the property by the liberal installation of wool insulation above ceilings, in the walls, and in the subfloor areas. So there was extensive insulation added to the property. The defendant and his wife had noticed common carpet moth, also known as common clothes moths, in the property, and some of his wife's expensive clothing had been damaged by moth infestation. The problem was sufficiently severe for the defendant to call in Rentokil and another specialist company, Environ, for reports and proposed treatment. Rentokil produced a very thorough report which suggested that the wool insulation may be the source of the infestation and would require extensive exposure work, removing high-end finishings in walls and ceilings, removing the insulation, replacing this with substitute materials, and obviously a considerable amount of work and expense would be involved. Environ, on the other hand, made no reference to the wool insulation. Unsurprisingly, the Woodward Fishers proceeded with Environ, and they instructed the latter, who carried out a spray of the property. Moths returned within a couple of months. A second spray was organised, and that was repeated for a third spray. Eventually, Environ resurveyed the property and came to the conclusion that the problem may lie with wool insulation. The defendant, who made a living from buying and selling houses and doing them up in the meantime, with the interiors designed by his wife, who was an interior designer. He contacted his clerk of works regarding the wool insulation material, and it became apparent, or at least it subsequently became apparent, that 2 different types of wool insulation had been supplied by different suppliers. One had treated the wool and guaranteed that theirs was not the problem. The other apparently did not reply, and the suspicion remains that this wool was the source of the issue. Nonetheless, after the third spraying by Environ, problem seemed to have abated somewhat. Why that was is unclear, but it might be suggested that it was out with the breeding season for moths, which apparently runs from April to September. So arguably, one might say that the defendants had realised that they had had a problem, had treated the problem, and it might be said had thought that they had successfully treated the problem. The plaintiff saw the property around September and made a lowball offer around that sort of time, which was quickly rejected. Matters seemed to be at an impasse. They returned the following February, and after viewing the property and considering questions such as train noise and light levels, they agreed to purchase the property for the 32.5 million, which I mentioned earlier. Much of the negotiation wasn't undertaken by the plaintiffs directly, and the plaintiff's solicitors were instructed by the plaintiff's private office. So I suppose with billionaires, it's quite usual to have a private office to deal with their day-to-day business, and that perhaps is not unusual. In the course of the conveyancing, standard inquiries were issued by the purchasing agents to the seller's agent, and 2.1 was in these terms: has the property ever been affected by woodworm, dry rot, or other timber infestation or decay, defects in drainage, water pipes, gas pipes or electrical wiring, damp, subsidence, landslip or heave, any structural, building or drainage defect, vermin infestation, asbestos. So I've highlighted the phrase which came to be litigated, and that is vermin infestation. After some discussions between the selling solicitor and the defendant, the following response was issued. The seller is not aware of any such matters affecting the property since the renovation and extension works were undertaken and completed, but has not had the property surveyed for such matters, so no warranty can be given in this regard, and the buyer must rely on the results of its own survey, inspection and professional advice. In short, no warranty was issued. However, there is a story there. The seller is not aware of such matters. Of course, once the plaintiffs moved into the property, it was the next breeding season, and moths started to emerge everywhere post-completion. The private office instructed a variety of specialist firms to survey and then treat the works, which appear to have some effect, but the infestations, well, they are infestations, continue to occur. Let's put it that way. Eventually, the private office became aware of the reports from Rentokil and Environ and discovered the wool insulation as the potential source of the issue. Thereafter, an action was raised, but it wasn't obviously based on the breach of contractual warranty because there was none. Instead, they sought to bring a claim on the tort, Delict Scotland, of misrepresentation, and on the basis that it was a deliberate misrepresentation or at least negligent, then they sought reduction of the contract and the land certificate and restitution, plus damages for any loss and inconvenience. What was the representation? The seller is not aware of any such matters. Ultimately, the questions that were to be answered by the court were fourfold, or at least Justice Fancourt decided that it should be determined over 4 issues. The first question was, were moths within the term vermin? Secondly, was there an infestation? Thirdly, was the representation false? And finally, was the representation relied on by the purchasers? So there we have the 4 issues which require to be addressed. So in relation to the first of these, were moths vermin? This is discussed in paragraphs 55, 56, and 57 of Justice Fancourt's opinion, and largely it might be said to be a game of dictionary roulette. The complete Oxford English Dictionary asserted that usage in Australia and America was sufficient to encompass insects within the term vermin, and thus moths in the UK, moths in Australia and America might be said to be vermin, but because the dictionary mentioned only Australia and America, then the assumption would be that in the UK, vermin was not so understood as to include moths. In the shorter English dictionary, shorter Oxford English Dictionary, the definition of vermin was sufficient to include moths. So 2 Oxford English dictionaries with different results. The Cambridge English Dictionary included insects, and the Collins English Dictionary included insects. Whether it included all insects or just some particular insects that might be regarded as vermin wasn't explored, but the court accepted moths might be vermin. The matter, of course, was one for probation. Justice Fancourt, however, departed from his 4-question scheme and determined that in order to ascertain whether moths were vermin in the circumstances, it was necessary to determine whether they amounted to an infestation. So he, in fact, dealt with his first and second questions together, which he seemed actually quite unaware of. Vermin here are therefore animals or insects that are capable of infesting a residential house and causing a problem to the occupier or the house. Something is vermin if it has the nature of infestation, in other words. So you can see quite clearly there that the 2 have been inflated. There's a complete failure to understand the circularity of that argument. Now, when you look at that construction of the argument, the look of vermin and infestation together, it looks very similar to the way of thinking that was adopted in Busby, the development of the argument there in relation to Japanese knotweed being within the scope of infestation in the Scottish Standard Clauses version 4 2.1.3 was determined in exactly the same sort of way. In Busby paragraphs 13 and 14, if something causes a problem to residents, it can be an infestation. So infestation is given a pretty broad definition by the courts, both in Busby and in the instant English case. The third question which the court had to address was whether or not there was a misrepresentation. Now, one particular strand of argument might be that the defendant did not think that moths fell within the term vermin. A second strand of the argument might be that the defendant did not think the presence of moths was so extensive as to amount to an infestation. So it might be argued that the seller was innocent in making the misrepresentation. But is that realistic? The seller clearly had knowledge of the problem. He had engaged specialist firms to examine the property, give a report suggesting treatment, and he had selected one of those firms to carry out the treatment. He had thus taken action to resolve the matter, which had been unsuccessful on his own knowledge on at least 2 occasions. So it's quite difficult for him to argue that he was unaware of the extent of the problem with moths, and clearly they were causing an issue in the property. So the only argument might have been that he did not think moths were vermin. However, in the circumstances, he chose not to disclose on the basis that moths were not vermin, and therefore it was out with the scope of the inquiry in the clause. So if we think about the misrepresentation, it is something that was in his knowledge, and given the court's view that moths could be vermin, it seems difficult to argue that there wasn't a misrepresentation. The defendant's final argument was that there was no reliance by the purchasers on the particular representation, such as it was. And they sought to argue, or at least his agents in the case sought to argue, that on the evidence provided for proof, there was nothing to suggest that information had been passed to and acted upon by the individuals. The only evidence was that some information had been passed on to the private office. Now, clearly, there was no information about moths because no information about moths was disclosed. So the defendant sought to argue that the purchaser had not relied on the assurance. The private office had received a very fulsome report on title from the agents, which clearly they didn't bother reading because they responded, "Is everything okay?" or words to that effect. Should we proceed? And the agents confirmed that it was. So if that is the reliance, then it hardly seems to meet the requirement of representation being relied on. Nonetheless, Sir Justice Fancourt held that the knowledge of the agent, in this case the private office, was knowledge of the principal. And since it had been relied on by the private office in order to give the instruction to proceed with the purchase, it had been relied upon. Fancourt founded on his own decision in Edwards against Ashik in 2014. Their solicitors again had produced a comprehensive report on title on property that was in fact a nightclub, but it really makes no difference. The responses received from the seller's agent to the purchaser's agent were not shared directly with the purchaser. But again, there was an exchange between the purchaser and the solicitors. Is everything okay to proceed? Which was answered yes. So Fancourt in these 2 cases has held that reliance has been made on those answers where those answers have been given to the solicitors, and the solicitors have evaluated those responses and reported on them in an anodyne sort of way. Now, this, I think, is correct, that the knowledge of the agent is deemed to be the knowledge of the principal, irrespective of how it is communicated. And it brings in mind the Scottish case of Franks against Ingalls, 2021, Clerk of Court, Perth, at 41. This concerned a new build block of flats in Dundee that was architect supervised. All the purchasers required mortgages to buy their flats and relied on a PCC, professional consultant certificate, issued by Peter Ingalls, confirming that he had designed the property, that he had periodically supervised construction, and that the property had been completed in accordance with his plans in a proper workmanlike manner. 2 or 3 years after the flats were completed, the owners started discovering problems with damp, and put short, they discovered that there had been significant deviations from the original design in relation particularly to the roof, and that this deviation or series of deviations had caused the defects which allowed rainwater to penetrate. It was held by Sheriff Drummond, as she then was, now Lady Drummond, that there had been no reliance on the certificates. Now, the certificates had, in 7 out of the 8 cases, been delivered immediately prior to settlement, but had not been passed on to clients. They would be sent on to the mortgage lenders, and it may or may not be that the purchasers of each individual flat were aware of the PCCs themselves. But clearly it is, or was at the time, matter for the UK Finance Scottish Lenders Handbook regarding PCCs. Now, on one level, I think it's fairly straightforward to argue that the case was defectively pleaded by the various pursuers in reference to reliance on the PCCs. The PCCs were in the hands of the solicitors. They had definitely relied on them. They required them for the purposes of the mortgage lending. And whether or not that information was directly communicated to the purchasers is perhaps unnecessary. So I think the pleading may have assisted in Lady Drummond, as she now is, reaching that conclusion. Nonetheless, in my view, the case is wrongly decided. If you look at the notes regarding the changes made to Scottish Standard Clauses version 6, there's now no reference to PCCs. And the notes specifically refer to the case of Franks against Ingalls, suggesting that there are difficulties with the wording of PCCs and reliance on certificates. So to remove any issue, the clause has been deleted from the Scottish Standard Clauses, and bespoke arrangements will have to be made in the missives relating to PCCs where there isn't a warranty scheme such as NHPC available. Franks against Ingalls, in my view, is wrongly decided. Fancourt's 2 decisions in England are, in my view, correctly decided and look at the realities of the conveyancing process. The professionals require to make a judgment on matters. Whether they explain the details of that judgment to the individual purchaser is something of a matter for them, not entirely, but clearly it would be a matter for them to explain that there was no warranty scheme here and that a certificate would be relied on by the designer of the building to the effect that he had supervised construction. I would expect that would have been done, but there's nothing in the pleadings or evidence in Franks against Ingalls to suggest that. Okay, what lessons can we learn from the English case regarding moths? Well, it seems to me that there is a common approach both in Scotland in relation to the standard clauses and in England in relation to the standard inquiries. And that is where a clause causes some concern to delete that clause and then provide an explanation as to why the clause has been deleted. And I think Martin Hogg, in his book on obligations, serves all of us with a very useful lesson, and that is that one should take an holistic view of the law of obligations, contract, quasi-contract, delict. They're all bound up together, so that if we end up with something that isn't warranted in the contract, it might nonetheless amount to a representation, and if false, a misrepresentation. That representation may come to be relied on by a purchaser. That may give rise to a delictual claim and opens up not only damages, but restitutio in integrum, which is probably actually worse than having a clause in the contract. Contractual warranty may only give a claim for diminution in value in most cases. So the moral of the story here is draft for certainty, avoid catch-all terms such as or any other infestation. So avoid catch-all terms in that situation, and please do not tell stories.